5 seconds to go. Start. The tribunal therefore sought assessment of probable duration of disability. Be that as it may, the appellants, in compliance of the order of the tribunal, convened a review medical board as directed and submitted a report. The tribunal noted from the Resurvey Medical Board dated 11th April 2019, held pursuant to our order dated 2nd November 2018, placed before us, it is seen that the appellant's disease, right partial seizure with secondary generalization 345, has now been considered as remained static and the degree of the disability has been assessed at 20% for life with effect from 8th April 2019. The board also assessed the degree of disability for the intervening period from 27th March 1989 and 25th March 1989 at 20%. The applicant has prayed for grant of disability pension. Significantly, even the Resurvey Medical Board did not opine that the disability, if any, of the respondent was either caused or aggravated by military service. Even otherwise, the question of entitlement of soldier to disability pension cannot be determined on the basis of medical examination conducted 20 years after his discharge. The tribunal does not sit in appeal over the expert opinion of a medical board holding that the disability suffered by a soldier was not attributable to or aggravated by military service. There was no reason for the tribunal not to accept the opinion of the Release Medical Board held on 30th January 1997, and no reasons have been disclosed. In the absence of any finding of infirmity in the decision making process adopted by the Release Medical Board, there could be no reason to direct the constitution of a Resurvey Medical Board, and in any case, not after 2 decades from the date of discharge. The tribunal relied on the judgment of this court dated 13th February 2015 in Civil Appeal number 2904 of 2011, Union of India vs. Rajbir Singh, heard and disposed of along with 23 other appeals. In the aforesaid case, this court dismissed appeals arising out of orders passed by the Armed Forces Tribunal and upheld directions for grant of disability pension to the concerned ex-soldiers. In Rajbir Singh Supra, it was not in dispute that the respondents in all the appeals had been invalidated out of service on account of medical disability as shown in the chart set out in the judgment. The judgment in Rajbir Singh Supra was rendered in the context of invalidation from service on medical grounds having regard to the provisions of the entitlement rules for casualty pensionary awards 1982, hereinafter referred to as the entitlement rules. Rule 14 of the entitlement rules referred to in Rajbir Singh Supra is extracted herein below for convenience. Cases in which it is established that conditions of military service did not determine or contribute to the onset of the disease but influence the subsequent courses of the disease will fall for acceptance on the basis of aggravation. A disease which has led to an individual's discharge or death will ordinarily be deemed to have arisen in service if no note of it was made at the time of the individual's acceptance for military service. However, if medical opinion holds, for reasons to be stated, that the disease could not have been detected on medical examination prior to acceptance for service, the disease will not be deemed to have arisen during service. Stop.